Further hearing in the appeal, Philipp against Barclays Bank UK PLC.
Yes, Mr. Sims.
Good morning, my lords. My lords, in relation to the starting point for my submissions, I was going to briefly just address the direction we received from the court the day before yesterday, and start by saying that we hope that we have correctly interpreted, ascertained, and acted in accordance with the truly intended instruction. But if we have not, then obviously we can explore further that issue in due course. The question I did want to hone in right at the outset, though, was to focus on this question, which is obviously we interpreted that direction as primarily wanting us to give you the juridical basis for the quince care duty. Yes. But there is a logical anterior question, which is where does that duty emanate from? And indeed, what is the scope of duty in relation to a payment instruction before you get to the question of the quince care duty? And we say that because the quince care duty is a secondary question which assumes that there is no positive duty before certain facts are drawn to the attention of the agent in the course of carrying out that instruction. So the quince care duty, as rationalised in the case law which we see, triggers a positive duty on certain events occurring, which are of course unusual events, in the course of carrying out that instruction. Moreover, there is no issue in this case that there is a duty as a baseline. It's admitted, it's common ground between the parties, that there is a duty to exercise reasonable skill and care in and about.
Well, you say that it may be common ground between the parties, but we are quite keen to try to focus maybe a bit more clearly than Lord Staines' dictum did.
Yeah.
What that really amounts to.
No, I recognise the second aspect of it, which was what that really amounts to. But the first part of it, which is there a duty, is common ground. And it was pleaded in our case and admitted. So, and the admission is that there is a reasonable skill and care required in and about the payment instruction. So that's the starting point between the parties on the pleaded case. There's been no withdrawal.
But that formulation raises all sorts of questions about what it really means and what its basis is. Hence the request for clarification.
Well,
how do you derive it conceptually?
Well, I accept all those sorts of...
You need to understand that in order to understand whether it can be extended or how far it reaches.
No, I understand all those points, and I'm not shirking from my responsibility to explore those points with your lordships. But I did want to emphasise right at the outset the importance of understanding what is common ground between the parties, even if your lordships want to explore those points further to understand whether or not actually that's an accurate analysis or not. And secondly, whether or not in relation to the secondary question of how does the quince care duty arise and what is its juridical basis, you have to start before you get to that point by analysing something before it. That was really the point I just wanted to emphasise right at the outset of our submissions. And it's linked in with the question of how the issues were framed for your lordships in the statement of facts and issues. Because, of course, we start in the statement of facts and issues at page 47 of the bundle, with jumping straight in at quince care level. And the logical reason for that, of course, is because we are reviewing the decision of the Court of Appeal, and the Court of Appeal's reasoning was that it's at least arguable that the reasoning in quince care is equally applicable to the situation of APP fraud. But actually, in terms of conceptual analysis, one starts actually more within point 2, and we would say indeed in point 2(2), which is how do we get there in circumstances where you are providing a service where you've agreed to exercise reasonable skill and care. and what is the ambit of the duties, the scope of your duties in relation to the service that you've agreed to provide as a contractual obligation to your customer. And that's the important starting point for the inquiry, which then takes us into the quince care duty, because certainly in terms of the established case law so far, the commonly accepted proposition is that it's an aspect of the duty of reasonable skill in care. We'll go on to the question of how you get there in due course, but that was really just I wanted to say right at the outset in terms of the framework for what we are exploring on this appeal. And I am not suggesting that we are not engaging in the secondary question and how we get there, but I just wanted to emphasise the starting point and it's not even, in this case, simply a common law position. It's a statutory implied term, which Parliament has recognised applies to all service contracts. Now, that starting point having been said, I will briefly just outline where we intend to go, just to give you some headings, which may assist you in terms of understanding where I'm going. And in due course, obviously, we will go off on different tangents, but just so you understand for our purposes. So we intend to start off with an introduction, including some of the key facts, which we would like your lordships to have in mind when assessing the appeal. Secondly, looking at the duties and an overview and looking at it from first principles, and as an aspect of that, address the direction from you as regards assisting your lordships with the juridical analysis as part of that. The third part was then looking at precedent, how far the case law has gone, both in this jurisdiction and also in the comparative law review. Apologies for troubling your lordship with it at the last minute, but we identified that the Zeng decision, in fact, has gone to the on appeal, and the appeal decision was handed down a day or two ago. So we provided your lordships a copy of that by email. It may not have.
Yes, we got that this morning. Thank you.
I'm grateful. We've got hard copies which we'll circulate so we can consider that when we get to it. And one additional authority on the question of policy, which we'll come back to in due course. So that was heading number 3, was how far has the case law gone, and we will try and assist your lordships on the comparative aspects of it, which I think you indicated was the second thing you were particularly keen for us to address. And then the fourth heading is policy and practice. And then, if there's time for a conclusion. So those are the headings that we've got. Now, so back in terms of the introduction heading, and I will try and remind myself to give your lordships the headings as I go through. But I wanted to explore with your lordships 3 stories: a bad news story, a good news story, and a puzzling news story. First, the bad news story, which of course is the rising tide of fraud, including the growing problem of APP fraud, which is a modern phenomena which exploits technology to the detriment of the customer. It's the Phillips case and many others like them who are victims of sophisticated fraud involving social engineering and trusted persons impersonation, whereby they've lost life-changing sums of money. That is the bad story, which is before your lordships. We are in the midst of, according to UK Finance, an epidemic of fraud in the UK. See page 1340. That was according to their own publication in March 2022. By October 2022, they were saying the level of fraud in the UK had risen to such levels that, in accordance with their own publications, they described it as a national security threat. That's at page 1265. The payment service regulator in November 21 said everyone playing a role in preventing scams needs to do more. That's at page 927. And have a responsibility to find solutions. That's at 931. Now, it's important to note this case is not about making banks an insurer for APP fraud generally. Mrs. Philipp does not seek to contend for some sort of strict or mandatory reimbursement, unlike certain legislative proposals aimed at domestic faster payments. Nor does Mrs. Philipp seek to make the bank liable for fraud generally. It is liability for damage caused by carelessness of the bank in the knowledge that such carelessness will probably result in the fraudster causing damage to their customer with no other likely recourse. And it arises as a result of information which comes to them in the ordinary course of them carrying out the payment instruction they have been given by their customer. So that's the bad news story and how we conceptualise what we are inviting your lordships to recognise in terms of the duty. Secondly, the good news story. The good news story is that the banking industry by 2018 had responded to the need to recognise and develop procedures to assist its customers in keeping their money safe and preventing them from becoming victims of APP fraud. They recognised that they had a responsibility, and they undertook that responsibility to put in place questions and procedures in relation to APP fraud. They recognised the need for action and took action, and by 2017 they had developed an industry-wide code, a passcode on fraud, which included measures to detect and prevent APP fraud. And we've given you a collection of the different measures in that respect in our written case at paragraph 6, page 11. I'll come back to some of them in due course. The duty Mrs. Philipp seeks to have upheld in this court solely concerns APP fraud and doesn't invite the law to travel beyond the industry practices or the reasonable industry practices in relation to the detection and prevention of APP fraud as existed in March 2018. The duty, as properly understood, is modest and sits within the already well understood industry practices, and indeed, if analysed at the quince care duty, within the already well calibrated refraining and inquiry duty concerning protection of the customer, that is, we submit quince care, or in any event represents no more than a principled, modest, incremental extension of it. The third is the puzzling news story. The puzzling news story, we submit, is the stance taken by the bank and UK Finance on this appeal. Do they think they are going to encourage financial and customer confidence in their industry by seeking to persuade this court that there is no common law remedy when they act negligently and fall below the standards set by their own industry, i.e. a reasonably competent bank? We submit it's a puzzling stance which is liable to cause concern amongst customers, and it is intellectually dissatisfying. The quince care duty in relation to fraud has industry practice baked into the test. At the first level of the trigger in relation to the quince care duty is the idea that it is only triggered if the bank in question has reasonable grounds assessed by reference to the ordinary prudent banker. You only get into the quince care duty if you pass through that gateway. So this is not some new duty or inquiry which Mrs. Philipp is foisting on the bank. this is a cake of the industry's own making, because by 2018, they were doing this. They were taking steps to detect and prevent APP fraud. The true issue here is whether or not they can persuade your lordships that, notwithstanding the fact they were doing it, you should reject any consequences in the common law for their failure to do what they themselves set for their task as part of the payment instruction. It would appear, actually, having listened carefully to the submissions, that their main concern is they don't want scrutiny or overview by the courts of the risk standards of their industry. They want to have voluntary codes or set standards themselves without any inquiry as to whether or not they are falling below any particular standards. Now, that is not an uncommon objection by those who carry out services or are potentially within the scope of a duty recognised by the common law. No doubt the manufacturers before Donoghue and Stevenson didn't particularly like the development of the common law in relation to manufacturers, nor the doctors before the shift in the law as recognised in Montgomery. But that's hardly a reason, in our respectful submission, for the common law not to take steps when it considers it's appropriate to do so. In formulating the duty in relation to the banks, we are not saying the bank has to engage in a search for the customer's subjective intentions or desires or actual mistakes, independent of what they are already doing as part of their payment task or obligation, but rather that the bank has to act upon the objective red flags that operate as objective indicators of what the customer may or may not have actually intended. Those red flags will be, and to a large degree already are, determined by relevant banking practice. It is only when the objective data within the bank's own control flags up a problem with a glaring mismatch with the customer's intention and a literal reading of that instruction that it is required to act by holding the payment and asking questions. The industry recognises that for large payments, which are unusual, this is a sensible course for them to take. In the past, this might have been a more onerous investigation in the days before IT and AI. Nowadays, the banks clearly have and should have systems in place, automation and algorithms in order to assist with an effective way of dealing with the risk of fraud on their customer. IT was a critical problem which led to the Philipps being sucked into this awful APP fraud, which they became victims of. And IT can help the banks and its customers solve the problem. There is a fundamental imbalance of knowledge here in relation to the risk that we are looking at. The fundamental imbalance here is that the industry is best placed to avoid the loss because the industry, by its very services that it provides, is in a better position, by definition, to identify that the customer is a victim of an APP fraud than the customer. The industry is in the best position not only to avoid that loss and for the courts to encourage the avoidance of that loss through the use of the common law, but also, in the event that that loss arises, to spread that loss amongst the industry. The ability of the banks to spread that loss is a good policy reason to recognise the duty, not the other way round as submitted by UK Finance. For the purposes of the present appeal, we would submit that you can identify 3 different categories or levels. Category 1 or level 1, which is where the duty of reasonable skill and care requires the bank to take some action to assist its customer in not becoming a victim of fraud, which we would submit includes APP fraud. That some action may involve, in certain cases, which present as unusual and displaying indicia of fraud, and are above a certain threshold, as we see as reflected, for example, in the money laundering regulations, above a certain amount. Asking questions, warning the customer, those sorts of things. There is no tension with any duty to pay by a certain period of time. This is a level below what we call the Quint scale level, or category 2. You don't even get into the question of how do you reconcile the duty to pay by a certain time with the bank being, in the extreme case, having knowledge of the fraud right before its eyes. You have the duty of reasonable skill and care triggered by those particular factors. There's a second level, which we call the Quint scale level, where there is a tension between the duty to act in accordance with the prima facie instruction and the duty to exercise reasonable skill and care. The ordinary prudent banker would consider that there are certain extreme facts which mean that they have to question their literal instruction. And that has been described in the case law, in particular in the recent Privy Council decision, JPSPC 4, as being a counteracting duty to refrain, which we would respectfully agree with. And the tension or conflict between the duty to act in accordance with instruction involves the law recognising the need for a counteracting duty arising from the duty of skill and care because of that conflict. And I appreciate your lordships have made some observations about is there or isn't a conflict, and I will come on to that point in due course. In our respectful submission, in extreme cases, there does arise a context, and those extreme cases are where what is happening is so extreme and unusual, so defeating of what a customer might reasonably be expected to want to achieve in a payment instruction, that the literal order instruction does need to be questioned. So that's the default rule, that's the Quint scale level. Then there's the category 3, and I've called them category 3s or level 3 because you can actually jump from category 3 at a lower level, which I'll explain in a few moments. Category 3 is where the express contractual terms may alter the default common law or statutory provision. Now, this may operate to alleviate any potential tension there might be between those two duties I've described, or in any event recognise, as a matter of drafting, the existence of a duty to refrain and pointing out to the customer that the bank can take certain steps to investigate because of that duty to refrain. An interesting feature in this case is that in our respectful submission, putting to one side the question of whether or not the contract incorporated the bank's standard terms or not, bank's own standard terms in our submission do that. In this case,
well, it gives a right rather than a duty, doesn't it?
There are two points in it which we want to draw out, 2 bullet points, and I'll come on to it shortly. The 2 bullet points are: one, a recognition of a right to refrain in relation to where there's a duty under common law, and the second is where they reasonably think that something is connected with fraud. And I'll come back shortly to what we say as regards how your lordships fit that in terms of the position in this case, on the assumption that there's a question of, we assume for present purposes that something similar to that is incorporated into the contract, without, of course, yet having had proof of that. But let's work on that assumption. And the cases can do, the contracts can do that. The contract terms can do that. They can also do something different, as we see, for example, the attempt in Singularis was to raise the level to gross negligence, or I think, as occurred in fact in Nigeria and JP Morgan, where they successfully incorporated a term which provided for gross negligence rather than simply negligence. And that may, of course, alter the default common law in relation to what the position is. That contractual alteration of the default common law statutory position is, of course, subject to legislative restraint in relation to unfair terms, because it's the bank standard terms. And so we therefore have an inquiry in that respect in relation to the Unfair Contract Terms Act or the Consumer Rights Act, depending on which applies. And not much turns on that for present purposes for this appeal, other than to note that there is, of course, that legislative restraint. Now, our case in response to the appeal, in short, is that the Court of Appeal was right to conclude that it is at least arguable a duty may arise in this case. And we say that the Court of Appeal was right to identify that agency fraud is a well-known type of case where the court recognises the need for a counteracting duty, which has become known as the Quince-Care duty. But the reasoning you see in that case law leads to the recognition of the refraining duty applying with equal force to APP fraud. That is the essence of the reasoning you see in those cases. It is not reasoning by reference to the question of the destruction of apparent authority by someone being on notice of actual authority. You don't see that reasoning in any of the cases. Now, in relation to the Quince-Care level, or category 2 as I've described it, there are broadly three different points of view or submissions being argued before your lordships. One is obviously the bank's printed case, which is that the duty here is properly understood, constrains to the agency paradigm. And our submission is that is inconsistent with the reasoning you see in the case law in those cases themselves, but also inconsistent with wider case law, which we'll come on to in due course. The second position, which is identified by the Court of Appeal, is that properly understood, at least arguably, that duty should be recognised in relation to APP fraud as part of a fraud genus, protecting your customer from fraud. The third, and we have sought to explore the third simply in order to illustrate to your lordships that the duty is recognised in case law going outside that. The third is a more general principle where the agent is on notice of special facts, where there's a serious and real possibility or risk that the very thing asked to be done by the customer is likely to be invalidated or destroyed based on a proper understanding of their true intention rather than the literal intention as recorded in the instruction. And that involves facts the agent has reason to believe its principal is unaware of. That's the key. APP fraud exists where the customer is unaware of the key fact that they may be subject to APP fraud. The bank, by reason of its sophistication and knowledge knows that on this paradigm case, or knows that there's a very real likelihood or real risk of that arising?
Well, if you put the test, you're not putting the test on as one of actual knowledge, are you?
On the basis of actual knowledge, no, we're not. And that leads on to actually conveniently the next point I was going to draw to your Lordship's attention, which is we explored to a certain extent with Mr. Goodall the different potential hypothetical scenarios involved in knowledge of an actual fraud taking place in front of the bank's nose and what it might do about that. And I just wanted to explore that in a little bit more detail with your Lordship's right at the outset. So let's assume I want to pay, my instruction is, I want to pay this money into this safe account. And the bank can say, just simply on the basis of what I've told you as part of the instruction, the indicia of the payment and who it's going to, what I know about you already, not inquiring any inquiry outside what you're already doing as a bank as part of that instruction, that they can tell you it's not safe. In fact, this is about the worst mistake you're about to make in your life. Now, your Lordship's teased out to Mr. Goodall in this court a departure from the position he adopted in the Court of Appeal. In the Court of Appeal, Mr. Goodall was not even willing to accept there was a duty in relation to knowledge of an actual fraud taking place in front of the bank's nose. That was his position before the Court of Appeal. And he's now sought to soften that before this court by suggesting that there should be, as I understand it, an implied duty to act honestly. Now, I may have been misreading his written case, but the two cases he referred to in his written case, I think it's Good Luck and Credit Lyonnais, don't appear to be analogous cases to the present. In our respectful submission, the obvious answer to that question is not the answer given by Mr. Goodall, but that simply to proceed in those circumstances would be a breach of the duty of care, the skill and care, to the customer. Why is that straightforward answer not given by Mr. Goodall? That straightforward answer is not given because he recognises it puts him on the same slope, which was the slope explored in Selingor, Carrack, Quintzcare and Lipkin Gorman, which ended up in the conclusion in all those cases that we see. But let's just put to one side the fact that my learned friend has not identified the authority which actually supports that proposition in the banking context, and let's assume that it's accepted that there ought to be an implied term that the bank should act honestly in relation to all its dealings with its customer, because one might think that's a sensible and acceptable proposition to adopt. It still leaves a major flaw in the analysis in relation to the factual position as a matter of principle. Let's assume that we have a transaction which the bank knows by reason of its knowledge of the payee, so a similar sort of situation to the one I think Lord Hamlin may have had in mind when he raised his question yesterday, that it's highly likely to be a scam, but the bank can't be sure. Some knowledge which comes very close to a finding of actual knowledge, but it's not. It's rarely black and white, isn't it? The bank will rarely know, actually. It's much more likely the bank will have identified as a likely risk or a highly likely risk, or indeed a real risk. Is it really the case that the bank can do nothing or even harder to explain, let's assume the bank knows that the matter is a scam, but unfortunately, due to the inadvertence of an employee, they forget to press the pause button on their IT system. That is just simple negligence. There's no way you can fit that into a category of dishonesty. It's a simple slip-up by the bank in their duty of skill and care in the payment instruction. The bank's position is that the loss must fall on the customer, even though the bank acted negligently in the service it provided to the customer. We do not understand how that can be justified in 2023, or indeed 2018. But a bank that's providing a service which is carrying out an act in relation to the payment instruction can come to the court and say there is no consequence for us carelessly, negligently carrying out this instruction.
There's another way of analysing it, perhaps, which is developed in a case you cite in your helpful one-page note, an Australian case called Ryan.
Yeah.
Where the analysis is, I think, that even when you're instructed to do something as an agent by your principal, there are circumstances in which that is subject to an implied qualification, that you will not actually carry out the principal's instruction. And he gives an example: you're told to hand over money to someone, that person tells you they're going to steal the money, you don't, your duty is not then to execute the instruction, because you read into the instruction an implied qualification that if you know the money's going to be stolen, you won't hand it over.
Absolutely.
And he identifies as the limiting principle there a situation in which you know that if you execute the instruction, the customer will be harmed. His limiting factor, as I read it, is actual knowledge. So in your example of the employee who fails to press the button, that would still be an unauthorised payment, because the mandate is subject to the implied qualification that where the bank knows the money will be taken in fraud, it does not have the mandate to make the transfer.
We'll come back to the question of Ryan in shortly. I don't disagree with your proposition that you can rationalise, starting from first principles, the expansion of the duty, if I can put it that way, as being coterminous with the retraction of the duty in relation to the mandate. You could approach that way.
There are implied qualifications on the mandate.
If you were to approach it in that way, you would obviously we would need to revisit our pleaded case in this case, and you're actually saying that there is no duty. You're saying that it's an implicit qualification on the mandate.
Yeah.
And then the question arises, where is the appropriate point at which to draw that level? Is it simply actual knowledge, or if you've got a high degree of probability as part of your knowledge? Or
generally, it's not for agents to second guess their principal's instructions, and so it has to be a very high bar before there's actually a duty not to do what you've been told to do.
The only issue I'd take with that is I think your lordship is probably looking at it from the point of view of the refraining duty, if I can put it that way. And well, there are two qualifications. One is that point, but the other is, I think it's a cart before the horse, or caravan before the car point, which is that in relation to that, you're presupposing that your lordship's identification of where the landing point is can be assessed independently of what the industry practice is. And in our respectful submission, if the industry landing point is they recognise a risk, a duty to act where there's a high risk, if I can put it that way, that actual certain knowledge, then in our respectful submission, the industry recognises that they have a duty to refrain at that point. Indeed, we would submit that the Quince Care duty, reasonable grounds, is the correct landing point, if I can put it that way. But I accept that your lordship's analytical framework could be adopted as a different way of approaching the same problem, if I can put it that way. And if your lordships are looking at it as a matter of first principles, as your lordships are, obviously we would then need to recalibrate, if I can put it that way, how we express our case by reference to that, because it certainly wasn't our appreciation. The point your lordship raised was how my learned friends were putting their opposition. They were not suggesting there is no duty, and your lordship's analysis would lead to that conclusion.
It's a much more coherent way of analysing the problem, I think, because than the one the Court of Appeal did. I mean, to say that there's a duty to comply with the mandate, but there's also a duty to protect the customer, and there's a tension between these duties to be resolved on the facts of individual cases, is frankly hopeless. If you say that there's always a duty on an agent to comply with his mandate, but you can read a qualification into the mandate, then there's no need to resort to tensions between conflicting duties. You have a clear duty. It's just a matter of defining what it is.
Well, my lords, as I indicated in my Lord Legate, I don't disagree that would be a rational way to approach it as a matter of first principles. Where I would disagree, with respect, is your suggestion that it's hopeless to contemplate anything different as a matter of industry practice.
I didn't say.
Maybe I misunderstood it.
The basic problem with your primary analysis is that you've got to find the source of the duty in the contract.
Well,
and if your contractual duty is to do what you've been told, then that's your duty, and you can't override that with some kind of obligation in tort. That's not how the hierarchy of obligations works.
Well, I'm coming on to that point to address specifically, if we're looking at it as a contractual analysis, what that instruction entails as a matter of implication into that contract. Your lordship's approach and analysis is obviously a sea change from the approach we see in all the cases, and I'm not suggesting that's outside your lordship's power.
Well, I actually got it from a case you cited called Ryan on your note, because I looked up the cases on your piece of paper last night, and I thought that may be why you'd cited it, because it's rather helpful.
Well, I'm glad that we've been of assistance, but I think I'll need to come back to the question of Ryan and where the landing point is in Ryan, and a proper analysis of that in terms of the law overall. But I think our concern is ultimately, of course, we want to assist your lordships in finding a rational juridical basis for the landing point, if I can put it that way. But there are two questions which I come back to. The one is the anterior question of before. Let's assume, for the sake of argument, in relation to this case, generally speaking, a 7-day period which is contemplated in relation to the international payments of this type. So during that period of 7 days, if the usual practice of the banks is to, in relation to transactions of this size, ask questions or give warnings about APP fraud, it may work, it may not. But if that is their usual practice, and we establish that at trial, then your lordship shouldn't be undercutting that. The second question is a different question, which is where do you step in as the law in saying you must refrain from carrying on, which is a question of law for your lordships to draw the line in relation to the refraining duty as a minimum, if I can put it that way.
But there's no basis in law for overriding what the parties have agreed here. I mean, there is if there's legislation, but in the common law, the source of the obligations is, in the banking contract, is what the parties have agreed, or what they've implicitly agreed unless they say something else. And if they've agreed that the bank will execute an instruction if certain conditions are fulfilled, then that's what they've agreed. And you can't override that with some extraneous duty to protect the customer.
No, you could. Your lordship is quite right that your lordships could approach it from a basis of an implied contractual duty, in other words, an expression of a contractual limitation on the mandate. That is a conceptual analysis which does work. The secondary question.
Well, what I can't understand that does work is the analysis in Quince Care itself, which seems to be that somehow, even where you've got a valid instruction that you're obliged, you've undertaken to carry out, that's somehow overridden by some kind of conflicting duty.
In our respectful submission, it's because it's a particularly unusual factual circumstance which the parties haven't expressly provided for in their contract, where the agent, so in this case the bank is the agent we're talking about, knows that its principal, or has a reasonable grounds for thinking its principal, is asking it to do something which doesn't reflect its true intention, because in fact it knows that it's a fraud, or it has reasonable grounds for considering it to be a fraud. That's why it's an ad hoc gap filler by the law, which gives expression to the reasonable expectations of the parties in relation to the contract, in the same way you have ad hoc gap fillers in relation to implied terms.
But there isn't a gap if you've got a duty to execute the instruction.
No, there's
no gap to fill.
There is
only if you can set a limit to that duty.
There is a gap if we assume, for the purposes of the instruction, if we take some, and I'm moving on to this in due course, if we take some examples of, I give an instruction to my agent, I want you to go and make this payment. And in the course of doing that, they identify, for example, that by making that payment, actually the money is going to be lost to me, their principal. I haven't given them the instruction, don't make the payment if in fact it's going to mean I'm going to lose the money. It's implicit. And it's implicit, and whether you use the test of Reigate's officious bystander, or if you use implied term as a matter of law, because actually it's an incident of the contract which is taken as read in the context of a banker-customer relationship, we say you sail over both those tests in relation to those particular circumstances. And really what Quince Care duty, proper rationalisation for it, is it was a recognition of an incident implied by law as a matter of practice, of customary practice, reinforced by the evidence of Mr. Redhead, the bank manager, who said that's exactly what he would have done in that particular case. And it's informed by policy considerations. And it's absolutely conventional, and it's absolutely correct in our respectful submission. But I'm not disagreeing that you couldn't analytically get to the same position by a different route. What I take issue with is that the end of that analytical process would result in a lesser standard, a lesser protection for the customer, if I can put it that way. And moreover, we would submit that that's a trial issue. There was no evidence adduced by the bank here in relation to the usual practices, in relation to industry practices as to what they do or don't do. And your lordships may consider that there's a certain baseline which should be arrived at in relation to what the law provides. But if the usual industry practice is different from where your lordships conceptually think it should be landed, then that shouldn't undercut what protection we should have as a matter of implication into the contract. Now,
you're not implying a term based on custom and practice, I don't think.
Well, I think
which has a high standard.
Well, I think that is a live issue, because we are saying that this was usual practice. We've said all along it's usual practice, and we recognise it raises a question as evidence in that respect as to what may achieve. But we certainly don't accept the proposition that, as a matter of fact, this was not usual practice.
But to imply a term based on customer practice, the standard is much higher than that.
Well,
It has to be universal.
in our submission, that's a live question. Was it universal as at March 2018? We submit it was.
Well, I mean, the contract can't change its terms over time. I mean, when was the banking contract entered into? Probably years and years ago. And you can't imply a term at day one based on a practice that develops 20 years later, maybe.
Well, my lords, the Court of Appeal in Tidal Energy arrived at the opposite conclusion. And I'm going to take your lordships to that point shortly. The Court of Appeal in Tidal Energy, Lord Justice Dyson and Lord Justice Tomlinson, both concluded that when you give an instruction to the bank in relation to certain type of payment, you are taken to give that instruction in accordance with the usual practice of the bank in relation to a payment of that type. I'll come on to that in due course. So, my lords, just briefly to deal with some key facts which we respectfully submit are relevant to your lordships' disposal of the appeal, because as a limb of our argument, as you are of course aware, is we submit that whilst we don't disagree that the appeal raises points of law which are properly for your lordships, there are actually factual questions which are controversial, which are matters for trial. Now, if I can just start out with the question of the recognition of the problem of APP fraud and social engineering, impersonation fraud that we see in this case. And I think during the course of submissions yesterday, my Lord Hamlin raised the question as to this being a modern problem, and I just wanted to draw your lordship's attention to a document at EC level, which a call for evidence in relation to payment services. It's at page 1976. Of the bundle.
I'm wondering how important this really is. This is an application for summary dismissal, wasn't it? So it proceeds on, in fact, it's a matter of agreement in the SFI.
Yeah.
It proceeds on the basis of the assumed facts summarised above in paragraphs 1 to 17 of the SFI.
Yeah. My Lord, you assume for present purposes then our contentions as regards industry practice is to be accepted?
The contentions as to practice don't actually form part of it.
No. So those are not agreed then? So, my Lords, can I...
Because that isn't how you... You're arguing it now as if it is some sort of case of professional negligence, where you're relying on professional practice on the basis of a duty to comply with the standards of a reasonable banker or something of that kind. That's not your case.
Well, my Lord, it is. At the heart of our case it's the start of our plea in relation to duties, is exercise reasonable skill and care in the services you provide in and about the payment instruction.
Well, so, in fact, we could forget about Quint's care.
Well, my Lord, you could. That's one conclusion that.
Well, you can't jump horses in the middle of a hearing.
I haven't jumped horses, my Lord. That's been our case right from the word go. It's my learned friend who is seeking to use by reverse engineering removal of that duty. And in relation to the question of industry practice and the perception of this being a problem, this point is relevant both to the Payment Services Directives point.
There is nothing about industry practice in the SFI, is there?
Well, in relation to the SFI, the uncontroversial facts were stated. In relation to the question of knowledge in relation to the payment services directives, at page 1976 of the bundle, Payment Services Directive 2 is described as seeking to improve payment security by requiring, and I'm reading to under the heading problem the initiative aims to tackle, and it's the second Roman numeral. PSD 2, improve payment security by requiring payment services providers to apply strong customer authentication. New forms of payment fraud have, however, emerged, in particular in online transactions. For example, cyber fraudsters trick their victims to breach payment security features, in brackets, authorised push payments, social engineering, etc. So, my lords, in relation to the question of this being a new issue for the purposes of the interpretation of the regulations, we can see quite clearly that perspective from the call for evidence in relation to that official document. So far as the question of these particular facts in relation to Mrs. Philipp, I would invite you to note the following points as a matter of the development of the recognition of the need to take steps in relation to APP fraud in relation to the customer. And, of course, so far as Mrs. Philipp is concerned, the customer relationship dated back many years, and your lordships are to take the facts, obviously, as set out in our pleading as regards the modest level of income and expenditure which is evident in her own account, and which is largely admitted. If your lordships look at the bank statements at pages 412 to 419, your lordship will see that's made out, and the transactions which arise in this case were highly unusual in circumstances described, amongst other things, by Lord Justice Burst in paragraph 71. The body of evidence as to the problem of APP fraud leading up to the material period started with the super complaint by Which in 2016, and they raised in an illuminating document the problems arising in relation to APP fraud and the potential justifications for the bank's resistance to it. And I'd invite your lordships to read, when your lordships have a moment, the objections raised by the industry in relation to there being any duty recognised or code brought in relation to APP fraud, and the analysis of that at pages 548 to 50. And it's under the heading 548, banks' conduct is not justified by any special characteristics of authorised push payments. It's up to the box 1 on page 550.
I've been looking at your particulars of claim, Mr. Sims.
Yeah.
As far as I can see, there's no reliance placed on industry practice, and indeed no averments about industry practice.
My Lord,
Duties. That accepted.
My Lord, we plead in our particulars claim reasonable skill and care. And
You say, fail to make such inquiries as an honest and reasonable man would make.
yeah, my Lord, the preceding paragraph, I think.
Yes, to observe reasonable care and skill in and about executing her instructions. That's from section 13 of the 1982 Act.
Yeah.
Yeah, when executing, in fact, it's at page 286, top of the page. When executing Mrs. Phillips' instruction to make fund transfers, Barclays acted as her agent and as such owed her a duty at common law as a term to be implied into the current account and or agency contract and or in tort and or pursuant to section 13 of the 1982 Act to observe reasonable care and skill in and about executing her instructions.
Yes.
Yep.
And my Lord, the way we put it in relation to industry practice is that what's reasonable skill and care is a dynamic concept. What was reasonable skill and care in relation to APP fraud in 1990 or indeed 2012 is not the same as reasonable skill and care in 2018. And what is reasonable skill and care is informed by the usual practice of the industry. So we get
Well,
there.
you're telling us that now. It's not part of your. That's not how your. It's not part of your particulars of claim.
Well, my Lord, I think you get to it in the same way, in the sense that if you ask the question to the witness at trial in relation to the question of reasonable skill and care, was it your usual practice to ask questions and give warnings in relation to APP fraud? And they say yes. And if you ask the expert at trial, was it usual practice or ordinary practice to give warnings in relation to APP fraud? And they say yes. Then that's a breach of the duty of reasonable skill and care.
I see.
That's how we put it.
I think it is true that the Court of Appeals accepted what you're now saying, and that their decision was that the duty is conditioned, as they put it, by whatever ordinary banking practice is at the time.
Yes, they did. And
The real question is there a duty of care of the kind you say that to which such banking practice is relevant?
yes, I mean, if you read through all the paragraphs in that particular page, you'll see that we do very much rely on the industry practice standards in the paragraphs following the ones your Lordship's looked at, for example, 59 and 60 and then 61.
Well, this is to do with knowledge of the problem of APP fraud.
Yeah, and the standards. So in 60, for example, we say the recognition of the need to have adequate measures being taken to address APP fraud. Mm-hmm. From the regulator, from the DCEO letter.
Yes.
So that's how we get there in terms of the reason why we say it's of relevance. Now, in relation to another feature which obviously will be gone into in due course should your Lordships conclude that the duty of reasonable skill and care, which is admitted, which we pleaded in our pleading, which is admitted in the offence, encompasses the activities that we're looking at on this appeal. It's of some significance that we have a publicly available standard in 2017 which Barclays were on a steering group for. If you look at page 656, you see that, which sets out the ambit of what the banks set themselves to do in relation to payment instructions and fraud prevention in relation to those payment instructions. And if I can invite your lordships to look at that, it's a document which starts at 653, but if you look at 661, you see reference to the definition of fraud within this document at 2.111 as identified there, and then in note 1 the note that the fraud can involve authorised or non-authorised payments. And I won't take your lordship through all the document, but I commend a read through it to see the level of detail the industry has gone to in terms of identifying what they should and shouldn't be doing in relation to fraud, including APP fraud. But in particular, what's illuminating is if you look at, for example, the steps they themselves recognise they should be taking at 5.3.1, and that's at page 673. And I invite your lordships just to read 5.3.1. Now, this is embedded into standard practice in relation to the industry by 2017. This is what they should be doing.
Well, you can rely on this to flesh out the content of the duty if there is one.
Yes.
But not for the existence of a duty.
No, you're quite right. And in relation to that question of the existence of the duty, we come back to the fact that in this case, the existence of a duty is admitted.
It's a question of what the admission amounts to.
Well, I agree. And then there's a second...
You can't get it out of the Supply of Goods Act, which you plead. That is a duty to carry out the services you've agreed to provide with reasonable care and skill. You can't conjure out of that a duty to take care not to carry out the service you've agreed to provide.
Well, in my respectful submission, you can, if the reasonable industry practice, as at that time, does recognise that in order to discharge care to their customer, they should be doing it. That's the industry.
Well, if it recognises something like that, it's not part of the obligation to carry out the customer's instructions it's recognising. It's recognising some separate practice to try and protect the customer from fraud.
Well,
and then the question is there a duty in law to protect the customer from fraud?
Well, in my respectful submission, it arises out of the duty of reasonable skill and care.
But it doesn't exist in the abstract duty of reasonable skill and care.
It exists in relation...
It has to be reasonable skill and care to do something or not to do something.
In relation...
And it's an obfuscation to say in and about the execution of the instruction.
Well, that's my learning friends and my position before this court on the commonly accepted case.
Well, you can take it we're not going to be endorsing that position.
Well...
It doesn't necessarily affect. I mean, it doesn't necessarily mean to say that Quince-Care is wrongly decided, but it's important to get the analysis right. And otherwise, it's a seed for confusion in the law.
Well, in my respectful submission, the proper conceptual analysis is that under the Supply and Sale of Goods Act case, the implied term to exercise reasonable skill and care in the service you're providing. The service you're providing is a payment instruction, and the question of whether or not the payment service provider is exercising reasonable skill and care cannot be disassociated with the question of what that particular industry in relation to provision of that service at that time does. It's a duty which is not to be resolved by this court in the abstract, but by reference to the particular industry and the particular facts before it. And if I can make good that submission, just to illustrate the debate we were having about where the landing point should be by looking at 8.2 in the same document at page 680. Now, hopefully your lordships will have got there. You'll see the heading preventative action. And if I invite your lordships to read through from 8.2.1 through over the page to the next heading, 8.3, remedial action. So not including that heading, but up to it on page 681, please. So you see that the industry code identifies three different categories: low risk, high risk, and urgent threats. And the urgent threats includes, amongst other things, you'll see over the page, asking for the police and then invoking the banking protocol, which I think was referred to yesterday in the course of submissions by Mr. McElroy.
If you're going to translate this into a legal duty, it would have to be a duty to protect the customer from financial harm. You can't get it as a duty to carry out the instruction take care in carrying out the instruction to ensure it's carried out carefully and skillfully.
Well, my lord, yeah. I think you do see that in the Quince care duty cases, don't you? You see the common law duty or limit is implied in law as a matter of policy. That's what.
Well, I think we're questioning whether there's any proper juridical basis for that analysis.
And in my respectful submission, there is, because it's an ad hoc policy-driven implication, which. Even if your lordships cavil at that, or one of your lordships cavil at that in relation to the proper analysis of it, and you go down the route of saying, well, we'll analyse this on the basis of an implication, a qualification on the mandate, the identification of that new way of looking at it, can your lordship satisfy yourself that that is completely independent of what the industry is already recognising itself in relation to this particular area it should be doing? And in my respectful submission, it would be a strange conclusion that your lordship should be taking away from the customer a protection which the industry itself might contemplate it should be providing at a lower level than your lordships would be contemplating as a matter of strict law. And in my respectful submission, that the way that that is analysed is to recognise that your lordships may consider that there is some sort of implication as a matter of law, but either the precise landing point in that respect is properly informed by industry what it's actually doing at that time, or in relation to reasonable skill and care.
There are all sorts of situations in which people are under regulatory obligations that don't translate into contractual duties.
But this isn't in relation to APP fraud. There's no one suggesting that there's a regulation which...
All right, internal practices, but the fact that the person you're contracting with chooses to conduct their business in a certain way and has internal rules and regulations and practices, doesn't that make those part of the contract?
Well, no, it's an objective approach. I agree with that, my lord. But it's a relevant factor, isn't it? And you see that in the cases as to they actually look at what the banks are doing in relation to the error, which informs them as to whether or not what they're doing is consistent with what a reasonably competent bank should or shouldn't be doing. But in relation to the question of as a question of reasonable skill and care. In our respectful submission, your lordships, in relation to the question of can that operate in relation to payment services, is been answered by legislation. It can. Your lordships don't need to approach it and shouldn't approach it on the basis that in some way your lordships restricts that. You just simply ask the question, in the course of carrying out a payment instruction, which is the service that you have been asked to carry out, have you done it in reasonable skill and care? And if someone in the industry is saying, at trial, the factual witnesses for the bank at trial is saying yes, and if the expert is saying yes, then on a conventional analysis, you're successful. And the oddity of
on this analysis, the reasonable skill and care is more onerous than an absolute duty, as it were, because if you had an absolute duty, you would have to carry out the instruction, come what may. And normally, when you say somebody only has a duty to act carefully and skillfully to do that, well, they may be excused in certain circumstances where they fail to achieve the absolute requirement. But you're trying to make that somehow into a position where it sort of overrides what a strict duty would involve.
Well, I respectfully...
That isn't legally coherent, I don't think.
I respectfully submit that in relation to the question of if your lordship is approaching it from the position of implication, and if we're tearing up what the parties have pleaded and what they've admitted and all of that, and one is analysing it from the point of view of implied as a limitation on the mandate, then it's an odd conclusion to arrive at that the parties were not taken to recognise that when there are extreme facts which challenge the validity of the instruction on the literal interpretation of it, that the court should not recognise that.
Well, that's going to the different analysis, which I put forward for you at the beginning, but you're pursuing the reasonable, you're pursuing the Section 13 of the Supply of Goods Act analysis.
We're both. We thought it was common ground that was the playing field we're on. If we're on another playing field, then obviously we're not saying to your lordships we're not playing, but we are saying in relation to that area too, my lords, your lordship should not end up with a conclusion in that respect which is at odds with industry practice as a recognition of customer harm. And we don't shirk from the notion that the policy underlying this is protecting the customer from fraud. That is the policy objective here. And your Lordship should recognise that and protect it in our submission. In circumstances where the industry has no difficulty in relation to that recognition. We can see it in front of us. Now, I'm going to skip through some other factual points, my Lord, in relation to, I think your Lordships have got the point in relation to the bank's own practices, that its own internal documents reflected a recognition of as an aspect of what it should be doing, what we see in this document in relation to the ID and V tool. And then, my Lords, we also have the question of the police tip-off on the 16th of March. Now, it remains a live question of fact as to if the bank took steps on the 16th of March, whether or not that would have resulted in us avoiding the loss we suffered in relation to the payment instructions on the 12th and 13th. No disclosure was being given on this point, which we requested before action in relation to the SWIFT documents, which might give us a better understanding as to when actually the payments left Barclays' control, or indeed whether or not they were recoverable by simple notice to the receiving bank before drawn by the customer. And that point has been pleaded by us and remains a live issue. So, my Lords, I need to probably keep moving, and because I think we were still in the introduction heading, but I think we've covered some other points usefully in the course of doing so, I hope, in any event. Second heading, duties, part 2, and as your Lordships would already have gathered, our starting point or proposition number 1 was that where a bank carries out a payment instruction for its customer, the common law implies a duty of reasonable skill and care in about the execution of the customer's orders, and that's been admitted by the bank in this case. But it's worth examining the roots of that in the context of the duties of an agent to its principal. Of course, our second point is that protection has been put on a statutory footing by reference to the legislative provisions which we've already referred to, Section 13 of the 1983 Act and Section 48 of the 2015 Act. The third proposition is that the bank is under a duty to carry out or obey or give effect to the instructions of its customer. And the scope of that duty depends, of course, on the purpose of the instruction, but also the usual practice adopted by the bank in relation to that type of payment instruction. And in our respectful submission, there are 4 reasons why APP fraud fits into the scope of duty here, even before one gets into the Quince-Care question. The first is the Selingor formulation of interpreting, ascertaining, and acting on truly intended instructions. And for the purposes of this submission, we would emphasise ascertaining and truly intended. The second is it's implicit when you give an instruction to the bank to carry out a payment instruction that the bank, in exercising reasonable skill and care, will do that in accordance with the usual practice operated in relation to a payment instruction of that type. The banks had accepted or assumed responsibility for taking steps in relation to APP fraud as part of their usual practices by March 2018. If that is controversial, as a fact, what the bank's practices are and their usual practices, then that's a question of fact for trial. Thirdly, the agency context must be had regard to when addressing the question of reasonable skill and care in relation to the duties being performed by an agent. And the scope of the agent's duties is informed by the customs and usages of the particular agency relationship. Fourthly, on the basis of the bank's own standard terms, assuming they or something similar to them are incorporated for the purposes of this appeal. Now, if I can invite your lordships to look at Story on the law of agency and go back some time to 1882 to see the roots of the agency approach in relation to the duty of reasonable skill and care. And the relevant discussion I was going to invite your lordships to pick up on is at the bottom of page 6832. And in particular, it really then starts at paragraph 183 on page 6833. The true rule paragraph. So we see inherent in the standard definition of the context of agency in relation to reasonable skill and care is to take care in relation to the activities they've been instructed to perform, employing the same skill as would be expected of persons operating in the same trade, business or employment, i.e. the same service. And that is conditioned by the common prudence those accustomed to use in relation to that particular task in hand. And we see at 184 that particular formulation and rule is traced back to Roman law. And we can see that in relation to, if we look, your lordship's Latin, I'm sure, is far superior to mine. But at the bottom of the page, by reference to the Roman law position, we see references to inexperience is accounted a fault. The person promises the skill of their art, and they promise the careful carrying out of their business.
This is page?
Bottom of 6834, so it's imperitia culpae ad numerata.
Yes.
And then spondit peritium artis being promising the skill of the art, and spondit diligentium gerenda negatio parem being promising the careful carrying out of the business. And there's then some discussion about obviously there's then the qualification in relation to that by reference to, at the top of the page, the reasonable skill and care belonging to persons in general engaged in the like business or employment, which we would place emphasis on. And then we see a discussion about, you see a little bit lower down, in another place it is added, and there's another Latin phrase, which is aimed at the question of whether or not the duty might be nothing more than good faith. And of course, that's recognised as not being the position now, and viewed as being something something which required much doubt and discussion. And then over the page, 6836, there's then whether the proper degree of diligence and skill which the law requires of agents in performing their duties has been applied is for the most part a matter of fact open for inquiry, and sometimes involving points of great delicacy and difficulty. The general usages of trade, the common habits of the particular business, and the special mode of dealing between the principal and agent will often explain and expound the duties required of the agent as to diligence and skill. So in our respectful submission, it's recognised in the agency concept that the common habits of that particular business is relevant to inform the scope of the duty of skill and care. As for paragraph 186, there's then the illustration of a factor who's employed to make a sale of goods, and there's reference to the duties not only being good faith but reasonable diligence, and it's not sufficient that he's been guilty of no fraud, of no such gross negligence. So we see the same layers of reasoning we see in the later Quince-Care cases. He's required to act with reasonable care and prudence in his employment, to exercise his judgment after proper inquiries and precautions. Now, of course, this has to be read in the context of the particular instruction and payment instruction involved. The same landing point doesn't apply to all agents, of course. But we then see that recognition that if certain facts are ascertained which are relevant to his master, such as discredit or insolvency, that is something that is a matter for inquiry. My lords, we say that that same basic reasoning, which we see in 1882, is the same reasoning which was adopted in the Quince-Care duty cases that we see in relation to the same basic reasoning, but with the added layer of the policy factors in relation to fraud. Now, my lords, recognising, of course, that in relation to different types of agency instruction, there will be different conclusions, but just simply looking at the principles, one sees in, for example, cases where the express instruction of a solicitor does not cater for them being required to carry out certain acts. Nevertheless, the law will conclude that if there are particular facts known to that solicitor or agent which have a material bearing on what their client is about to do, they have a duty to point it out to their client. See that in Mortgage Express Limited and Baumann, 1996, 2 R 836 at 842F.
8.
My lords, I think that was an additional case which we've included in our note. We can hand that up now if your lordships want a copy of that to briefly look at it. So, my lords, if you look at the headnote, you'll see this is a solicitor duty case where the solicitor was acting for both the mortgage company and the other party, and there was a back-to-back transaction at a lower price. And the question arose as to whether or not the fact of knowledge of that back-to-back instruction, which was not expressly catered for by the instruction, should have been brought to the attention of the plaintiff mortgage lending company. And Sir Thomas Bingham, in his judgment starting at page 837, recognised it didn't form part of the express instruction, but nevertheless at 842F recognised that if in the course of carrying out that service, i.e. investigating title, a solicitor discovers facts which a reasonably competent solicitor would realise might have a material bearing on the valuation of the lender's security or some other ingredient to the lending decision, then it is his duty to point this out. Now, it may be said against me, well, that arises in the context of a solicitor's instruction, which is very different from the banking context, to which I have two responses. The first is that it's an express recognition in the context of agency of a duty, in this case a duty to warn, which arises outside the instruction by reason of it coming to the attention of the agent that there's some material fact which is not known to their principal, which has a material bearing on it. Secondly, there is the same recognition of that duty in a banking context in relation to, for example, insolvency of the payee bank in Royal Products. The decision in Royal Products has got nothing to do with authority, has nothing to do with fraud. But it was analysed and approached on the basis of a material fact, reasonable grounds of a material fact, which the agent, in the course of carrying out their duty of reasonable skill and care, had in some way a duty to try and protect in relation to their principal. And in relation to Royal Products case, there's a conventional analysis of that arising out of reasonable skill and care, which was following the decision in the House of Lords of Hilton, and also the early cases in Selangor and Karak, and involved an acceptance that where the agent has reasonable grounds, so the same landing point as we see in relation to fraud, that the customer's money is likely to be lost by reason of carrying out the literal instruction, there would be a duty to refrain. Now, my learned friend is quite right that the facts are complicated, because what we have is a finding of fact by the judge that for the course of one day there was knowledge that the payee bank was insolvent, and then there's a finding of fact that that shifts by the end of the day to a recognition that in fact the bank no longer had knowledge of insolvency in something less, concerns maybe, but something less than that. And in relation to that approach, the judge correctly identified that the question which arose then was, what would ordinary reasonable banking practice have required? And the claimant had adduced no evidence to support the proposition that ordinary banking practice required something to be done akin to the refraining duty in relation to quince care on that particular low level of risk, if I can put it that way. But it's illuminating for a number of reasons, but in particular because it chimes with the same principle which we see in the Mortgage Express case and indeed in cases like Ryan, of some special fact coming to the notice of the principal and an acceptance that that flows naturally from the exercise of reasonable skill and care in the service provided and as an incident of the instruction. It could equally, if your lordships were to take a different route, it could equally be rationalised on the basis of an implied term, obviously, into the mandate on the same basis. Of course, we would need to adjust our pleaded case if your lordships were to go down that route. Now, if we now...
Sorry, just on that. I mean, if one is adopting the analysis of implied limitation into the
mandate,
basic mandate,
yeah.
And presumably that would be on the footing of the usual difficult test of implication of terms. And does that not in itself push one to the extremes, that it's only in an extreme case that the mandate would be qualified in that way, which might be an indicator that it's actual knowledge of the harm that is required rather than suspicion and so on, because the more that you push back into the mandate saying, well, this might not be good for my principal, I'd better tell them, the more you're undermining what is otherwise a feature of this particular mandate, that the principal wants you to act on it straight away and may suffer loss if you don't.
I can see what your lordship is saying on that analysis, but in my respect for submission, the same fundamental question arises, whereas a matter of natural implication, whether it's Reigate test or business necessity or anything else, as a matter of reasonable skill and care, if the principal is about to suffer a particular harm due to knowledge of a fact which is known by their agent not to be known by their principal, or that there's a material risk that is so, it doesn't need to be actual knowledge, then an implication is justified in those circumstances, because for the same reason you see in the Mortgage Express case, it's not conditioned on the basis of the extreme. And there may be a variety of different possibilities depending on the particular type of payment instruction as to how severe that is or not in terms of the detention, if you like, if you're viewing it one way in terms of duties, or if you're looking at it in terms of qualification on the instruction to pay. But if you pose the hypothetical question to the person who is giving the instruction, if my agent acquires information or has knowledge of a fact, in this case APP fraud, which I don't know about, would I expect that agent to tell me? To which our response is a testily, of course.
is it?
Yes.
Yeah, suppose the principal has given an instruction to complete a transaction, time's of the essence. If they don't complete it immediately, they lose the whole transaction, may be liable in damages, all sorts of things.
Well, let's assume...
Is it a testy of course response when the bank says, "Oh, shall we hold up this payment"?
If there's a real risk that the money is about to be lost as a result of, for example, the insolvency of the payee bank, yes, I would have thought every single person who's giving that instruction would want to know that information. They would expect their agent to tell them. Now, I recognise that there may be some extreme facts where you'd say, well, if the payment instruction is to do it within 1 minute, there's no scope for that duty to bite, potentially.
Why not?
Well, it may. Let's assume, okay, as soon as the instruction is
I'm not sure the 1 minute actually changes the parameters of the debate, because the usual rule is do it promptly, do it very quickly.
Well,
You just said 1 minute, okay, that's super quickly.
well,
The usual position is do it very quickly. That's the understanding. As to
well,
what
is
you should do.
it that, or is it within a reasonable period of time? It depends, I suppose, on the instruction. I mean, in this case, it was instruction to carry out the instruction under an instruction which provided for no particular time. But assume for present purpose it is promptly, rather than within a reasonable period of time. Then I would agree if the bank immediately has notice of a risk that that your principal's money is about to be lost, a real risk, not just a speculative risk, but reasonable grounds, you would expect your agent to tell you.
Right. Yes. Thank you.
So you're putting it on actual knowledge of a real risk.
Actual knowledge of a real risk, yeah. But that's not to mean that they actually know that there is an APP fraud.
I mean, but that casts it very wide, doesn't it?
Well,
I mean,
it's
I, as a principal, might make all sorts of rather imprudent arrangements with people.
well,
Where the bank, because it does have access to more information, perhaps as to the solvency of the people that I'm dealing with, might think, well, there's a real risk that I might suffer if I go ahead with this. And that seems like a very major intrusion into the usual relationship between banker and customer, that, subject to extreme circumstances, to use the formulation of counsel in the Lipkin case, or actual knowledge of something really terrible going to happen to the principal, which I take from Ryan, the burning dock.
yeah. Well, yeah, but that exists in APP fraud scenario, doesn't it? You are about to make the worst mistake of your life, and so does the court in that circumstance set the bar high? And that's why we go back to the question of the policy debate.
Right, but I mean, I'm sorry to press you on this, but
yeah.
Take my time of the essence contract. If the bank doesn't execute, I'm about to lose the best deal of my life.
Well, I think my ultimate position would be, what would a reasonable banker do in that circumstance? Would a reasonable banker, on notice of that particular knowledge, just carry on with the transaction, or would they press pause? In my respectful submission, your lordships should inform your conclusion on that point in relation to APP fraud by what the reasonable agent would do. And I accept that your lordships may conclude that a reasonable agent on certain factual criteria would not do that. But ultimately that takes you into the territory we see in the cases Lipkin-Gorman, for example, in the Court of Appeal, of Lord Justice May, recommending that you don't seek to lay down a detailed rule, but you simply ask the question, what would the reasonable agent discharging that service do in that circumstance? And the facts are infinitely various, as we've explored in just a few exchanges today. So we accept that the landing point for the inquiry, if you like, or even for the trigger of the duty, is to be informed by reasonable grounds of an ordinary prudent banker. And that is a modest level of intrusion. And it, of course, is the same level as is adopted in Quint's care, in a context where you would expect, if anything, the duty to be less attractive to the court. Because in Quint's care, the court is recognising a duty to the customer for a fraud on the principal by someone, an agent, who they are responsible. Yet even though that is recognised, the court is saying in the cases, the reason why we are accepting a duty in this case is because the purpose of the duty is to protect the customer from fraud. And so in the Quint's care classic context of the paradigm example, we are even going to conclude that even though this is someone who you would ordinarily be responsible for internally, we're going to recognise a duty. That's got nothing to do with an inquiry in relation to agency and authority. It's assuming there is a valid instruction. And it's recognising, requiring the duty to inquire in certain factual circumstances because of the policy reason of fraud on the customer for someone who they have control over. And the court says in the Quint's care classic context, even in that scenario, we're going to recognise a duty. Now,
sorry, I don't want to break you in too much, but just going back to the question of if one's looking for an implied limit on the mandate. The debate we were just having is looking at it from the point of view of the customer. My fantastic deal, your terrible loss. One has to look at it also from the point of view of the bank. And again, might it not be said that the bank needs clarity? You know, you say the implied limit is behave as a reasonable banker would do, but there could be lots and lots of argument about what a reasonable banker might or might not do in a particular situation. Doesn't the bank, from its point of view, want clarity as to how it should proceed, rather than leaving itself exposed to possible claims either by disappointed customers, either because they've lost a fantastic deal or because they've suffered loss? So when the bank is providing a service like a pure banking service, making payments when their customers ask them to pay, from the point of view of the bank, doesn't it want as clear a rule as possible, which again, it might be said, pushes whatever qualification there may be of the mandate to the outer edges, probably actual knowledge, because that's when the bank knows that, I shouldn't do something now. Whereas before that point is reached, it's dealing with a sort of a drift on a sea of uncertainty, and there may be risk for it whichever way it jumps, if it is truly going to be liable according to what a court might later decide was what a reasonable banker should not have done.
No, I have to accept, don't I, the logic of what you're putting to me, which is that if you were to simply say the bank is just to make the payment with no intrusion of anything else, then it's more certain for the bank and the customer. It's more certain for both of them. I have to accept that. That's logical. But what you lose by doing that is you lose a recognition that both the banker and the customer, in the context of the payment instruction which is made in this case, if you pose the question to them at that particular time, do you expect X, Y, Z to be drawn to my attention or done? The evidence one has to take for present purposes is yes. And you lose the ability to protect the customer from fraud in particular. Now, my lords, I've not drawn your attention to the wider case law in order to try and...
Can I draw your attention to one authority in the wider case law?
Yeah.
I've only read the head note. I don't think we've been taken to it yet. It's the decision of the Supreme Court of New Zealand in Westpac.
Yeah.
And that's a case where it's at page, I can't quite read it on my machine, but I think it's 6217.
Yeah.
And it's a case where the bank is sued by its customer because it did not give effect to the instruction because it was suspicious that a fraud was being perpetrated. And the Supreme Court, according to the head note, held that the bank would have a defence only if performance of the mandate would actually, rather than potentially, have rendered the bank liable for dishonest assistance. There was no basis for intervention on any lesser threshold. Banks would be liable only if they actually knew a breach of trust was intended or were willfully blind to that intention. And in this case, the bank couldn't show that any breach of trust would actually have occurred had it followed the instruction, and therefore had no defence to the claim for breach of mandate.
Yeah. So in relation to Westpac, it's the case which I think Professor Watts places heavy reliance on in his analysis.
Well, I'm reasoning with you because it's obviously contrary to a submission you've just made to us that knowledge of a risk is enough.
And in my respectful submission, it's not when properly analysed because of the facts in that case.
Oh, I see.
So if you look at the facts in Westpac, properly understood, what was going on here was not about protecting the customer from fraud, but protecting a third party, like JPSPC 4.
Yep.
If you look at the head note and the holding, you can see it's not about the customer, and you get further support for that in terms of what the court was really aiming at in that case. If you look at the judgment of Mr. Justice Tipping at page 6222, where if you look at page 6225, footnote 7, in terms of the issue arose and the way it was argued, was not on the basis of the best interests of the customer or a breach of duty of care to the customer. If you look at the top of page, for example, 6225, understandably, that submission was not being made, notwithstanding the fact that quince care as a concept was recognised in footnote 7, without demur or criticism. So, in our respect for submission, the proper analysis of Westpac and MAP is it marches along the same path that the board did in JPSPC 4, which is to say when you're dealing with the question of the interest not of the customer, but there was someone else who might be beneficially interested behind that customer. And that was the way that the matter was argued and submitted. So the point just simply wasn't taken and wasn't debated or argued on that basis. Well, look, can I briefly go back to...
It does rather make the point. I mean, it supports the view, I think, that we've been taking of the analysis. The point being emphasised if we're out the page you took us to, 6225, is that liability for breach of a contract, or such as a banker's mandate, is strict.
Well, of course, contractual.
So if it's to be any, if it's to be any defence available to the bank for not executing an instruction, it has to be because that defence is built into the contract.
Well, it arises by reason of an implied term, and you cannot read into this case a rejection of the quince-care duty because it wasn't argued on that basis. I accept that for the purposes of viewing it from a point of view of equity, that comes through very strongly. And that was the same reasoning and rationale as the why, in effect, in JPSPC4, the court was unwilling to expand the recognition of a duty of third party on the basis that it said, well, actually, we're dealing here with a third-party interest scenario, and the courts don't, obviously, in those circumstances, look at the question of interest between the customer and the agent and the implied duties or restrictions in relation to that scenario.
But I mean, couldn't it be said that the strictness of the liability has to have some reflection in the nature of the duty that is taken on? Because there's a strict liability that follows from breach of the duty, might it not be said that that is itself an argument why a bank needs to know very clearly indeed what it should do in given circumstances?
Well, in my respectful submission, you arrive at the same landing point in the sense of if a reasonable banker would reject the payment, as in, for example, the Amy decision in Singapore, they have protection. So in that case, in the Singaporean Court of Appeal, the claim by the customer in that case that the bank had failed to act in accordance with its instruction failed precisely because the implication protected the bank. And really, what the debate involves is, should your lordships conclude, as a matter of some special policy reason, you take the banks out of that general expectation of reasonable skill and care in relation to the response to a fact which arises in the course of their instruction. And
you could make the point that in quince-care itself, in that line of cases, it's not a clear and certain test as to when there are reasonable grounds for believing that the director is acting dishonestly. There is a judgment involved.
There is, and there is in every professional service, or
it's not a duty that arises only when you know that the director is arising dishonestly.
Of course, I accept that. That's part of the careful calibration of the test. But the question for your lordships is that an unreasonable thing for a service provider to have to address. And in our respectful submission, there is no obvious reason, short of the bank simply wanting to be given special treatment, for the natural landing point to that being, if the agent acting with reasonable skill and care would carry out certain action, whether that's ask a question, give the information to their principal, or nothing, that is the landing point for both sides. It protects the bank and it protects the customer. And really what's going on in this appeal is they're seeking to shift, your lordships, away from that position for APP fraud, yet they certainly started off their grounds of appeal recognising that was a sufficiently narrow and certain test for the purposes of agency fraud. There is no challenge before your lordships on that point, so your lordships have obviously raised that with the parties, but it's significant in my respectful submission in terms of your lordships analysis that it was not part of the bank's case that reasonable grounds provided an unworkable, unsatisfactory test which they could not apply in relation to agency fraud. That being their position, how in the same breath do they say something different, more onerous applies in relation to APP fraud, is not articulated satisfactorily anywhere in the bank's case. And all their points are predicated on an assumption that this test has worked perfectly satisfactorily since the 1970s and 80s, for over 50 years. Their objection on this appeal is that in some way this is going to cause problems because you are in some way significantly widening the Quintscare concept. Their case on this appeal is not that the Quintscare duty itself causes them any difficulty, but yet that inquiry, the threshold for it, is said to be objectionable now when you're applying it to a retail customer.
Just taking up Lord Leggett's point about an element of uncertainty for the bank, or the need for the bank to make an evaluative judgment in the Selangor and other cases. I mean, again, of course that's right, but perhaps one's needing to have regard to the extent of the uncertainty that is introduced for a bank in any particular case. And in those cases, the uncertainty is simply in relation to the bank checking whether an instruction has been given within the terms of its mandate. And one can see that in order to make sure that you're actually within the scope of the contract, where there's doubt about that, the obligation to check may be that much wider, because the strict liability doesn't come into effect if you're outside the mandate. But I mean, I'm not sure that that means that any element of uncertainty can be imported into the mandate, because obviously when you're looking at the sort of matters that you're inviting us to say are brought in to qualify the mandate on this alternative analysis, there's a much wider range of uncertainty that would then be imported into the mandate than would follow from a simple duty to inquire where there's doubt about whether your instruction is within the mandate.
But I'm not sure if that's right as a matter of, there is no evidence before the court that is so. So there's no empirical data before this court that the fact scenario of APP fraud is more onerous for the bank.
But I mean, isn't just a logical point?
Well, I don't accept
duty to inquire if you're not sure you've got an instruction.
I don't accept the logic of the proposition that an inquiry in relation to authority is any less or more onerous than an inquiry in relation to APP fraud. In fact, we would say the opposite. Inquiries in relation to authority in a corporate context can be quite onerous and complicated. They can involve the bank in the tricky scenario of not knowing quite what to do where, for example, in the Alcinia case, the person who's giving in the instruction is the fraudster.
Yes, thank you.
And in the scenario where, in relation to the difficulties that arise in the authority context, and no less, we would say, higher problems for the bank than in relation to APP fraud, because in relation to APP fraud, your inquiry is customer focused on the person who's actually giving you the instruction in relation to facts which are already known to you. It's much easier. And there is no evidence before your lordship, any empirical data, that this is going to cause any problems. And the submission it will is completely destroyed by three pieces of evidence. One is the PAS code, the second is the CRM code, and the third is that they're planning on, they say, accepting strict liability in relation to APP fraud as a regulation which they say they welcome in relation to faster payments. But you can't simply square those two positions.
In the New Zealand case, it's interesting to see that Mr. Justice Tipping relied on the decision of the House of Lords in Gray and Johnston back in the 1860s.
Yeah.
And if one goes to 6227, after summarising what was decided in Gray and Johnston, he says in paragraph 24, the decision in that case was based substantially on the need and the interests of commerce, there to be a strong prima facie rule that banks should ordinarily honour their customers' instructions. Only very limited exceptions from that rule were appropriate. One of them was where to do so would make the bank party or privy to the commission of a breach of trust.
Yeah.
Banks will become liable in that way only if they actually know the breach of trust is intended or are willfully blind. So the fact that Gray and Johnson was decided a long time ago doesn't mean to say it's no longer of...
No. I think Gray and Johnson actually is a modern reflection of the same principle as JPSPC4, because in Gray and Johnson, it was not the customer's interests that was at the heart of the inquiry. In Gray and Johnson, it was again a third party. So, and my respectful submission, Your Lordship, is absolutely right to draw that to my attention and to note that it's consistent with our reading of Westpac, which is it's about the interests of a third party. And we would not demur from the proposition that ordinarily they should honour their customers' instructions. We are not in the territory of urging on Your Lordships a position which is going to cause problems with the banking industry. But Your Lords, I think Your Lordships were taken to a passage in the latest textbooks in New Zealand yesterday, you may recall, by Mr. Goodall in relation to one of the recent cases which we may come on to after lunch, where the latest modern position as a matter of New Zealand law was summarised in, I think, Tyler from memory, the textbook. And that recognises that the basic principle which is applicable in New Zealand law is to recognise a duty to protect the customer from fraud, not on a narrower basis as suggested. And in my respectful submission, that position is replicated across the common law world. If we look at as a matter of comparative analysis of where Your Lordships may land in relation to the issues before Your Lordships, it is significant in my respectful submission for Your Lordships to take into account the fact that in relation to the different Commonwealth jurisdictions, they all recognise a duty to protect the customer from fraud as a duty. And They recognise that because that's a valuable right to the customer. And when you're assessing the two competing considerations of commercial efficiency and customer protection against fraud, there is no good reason, in my respect for submission, to alter the landing point for APP fraud in circumstances where we can see that the quint-scare level of protection has not caused problems at all in any of these jurisdictions. The banking systems in none of these countries is caused any difficulties or challenges as a result. I'll come on to a more detailed analysis of the comparative law shortly, but just to pick up on a point about how the first instance courts view Philipp in the Court of Appeal. And it's a significant point to note in our respect for submission in this context that we're now 11 months on since the decision of the Court of Appeal, and we have the benefit of a first instance decision of Mrs. Justice Cockrell in the Federal Republic of Nigeria case. And at paragraph 154, at page 2336, she says the authorities, including Philipp, do indicate that the duty is narrow and confined. Those are her words, from someone who's been influenced by the Watts analysis suggesting it's all wrong. And you see her review of the cases, and then her formulation at paragraph 158 of the narrow nature of what's required of the banks. Namely, the duty arises in relation to the payment instruction. A clear focus on the issue of what it is the bank question must be on notice of. Unless the bank is on notice that the instruction in question may be vitiated by fraud, that the payment instruction is an attempt to misappropriate the customer's funds, the duty does not arise. Now, of course, those words, vitiation, misappropriation, are not being used by her in the belief and knowledge that the property ab initio rights are affected. It's directed at the question of vitiation in the sense of fraud affecting the transaction. And the reasoning in that respect, in my respect for submission in relation to misappropriation, is act in circumstances where the consequence of the act is indeed a misappropriation. The consequence of the instruction is the customer's funds are misappropriated as soon as it lands with the, as soon as it leaves the bank who the customer has an account with. So the proximity of the facts in an APP fraud context with the paradigm agency fraud context are best buddies. They're not a long way away. They are so close, in fact, that when we pleaded out the duty in our pleadings, it was admitted in the defence, until we then were educated that in fact the admission didn't go as far as we thought it did. This formulation of APP fraud in relation to the instruction in question being induced by fraud and the payment instruction being an attempt to misappropriate is narrow and confined. It's been applied and satisfactorily applied at first instance by the courts.
Well, I read Mrs. Justice Cockrell's judgment as saying I don't like this decision, but I'm going to interpret it as narrowly as it's open to me.
Well, she's influenced by the Watts analysis, and it may just be briefly worth looking at the Watts analysis, because in my respectful submission,
she describes there as being a slender basis for it, I think.
She describes it as a slender basis, but in circumstances where it's existed for over 70 years, and you can see it traced back into Hilton and Westminster Bank, selling law, carrot rubber. There have been plenty of leaps in the law based on a lot less. Donaghy and Stevenson, for example. In relation to the question of the principles of it in relation to this, let's just pose this question. Assuming that your lordships are debating amongst yourselves, do we rationalise this as a duty or a restriction on the mandate? In our respectful submission, if the end point of that conclusion is you are not entitled, as part of your reasoning, to take into account the public policy factors of fraud, in our respectful submission, your lordships have gone wrong. Your lordships should be taking into account the public policy factors of fraud in recognising whether or not a duty should be recognised as being at least arguable. And in our respectful submission, I think we briefly dealt this in our written case. The Watts analysis is simply an inaccurate description of the conception of the duty in Quintscare. The Watts analysis takes us to a passage in Bowstead, and he says, well, that says that doesn't recognise that agents owe duty of reasonable skill and care. Well, if you look at the passage in Bowstead, which we've given your lordships a reference for in our written case, you'll see it does. It's a passage in Bowstead and Reynolds which talks about reasonable skill and care in relation to agency, not restricted to discretionary agents. It's wishful thinking on the part of Professor Watts, not actually an accurate reading of the judgment. And if
I'll probably say something different in the next edition.
There needs to be some controversy amongst academics to get some writing. There is, I think, an error in the bundle. My junior's just drawn to my attention in relation to one of the authorities which we intended to give your lordships the benefit of looking at. If you look at the footnote in the edition of Bowstead, which is relevant to ascertaining whether or not Mr. Justice Steen just simply didn't look at the text properly when formulating the decision, there's a case called Beale, which we've included in the authorities bundle, and we included the wrong version of it, so apologies for that. It's a slightly complicated state of affairs involving exchequer courts and then appeals from the exchequer court to the exchequer chamber. So we've got a hard copy of the correct version of that for your lordships, which we'll give to your lordships so you can have that over the short lunch and adjournment. But I'm going at things at quite a pace, and I hope that I'm not going too quickly. But in relation to that particular point and the point we draw from it in relation to the Watts analysis is that actually if you look at the reasoning in Quintscare, it starts with an orthodox proposition, which is that there's reasonable skill and care in the service being provided. The phrase used in and about is entirely, in our submission, unobjectionable phrase which has been used by courts ever since. But even if one just takes the formulation in the statutory text, what's going on in Quintscare is not the starting point in that respect, but it's how you address the situation of the agent having firstly knowledge of fraud on its customer, and of course that scenario is taken for granted, but then ask the question, what's the logical stopping point in circumstances where there's a high degree of suspicion but not actual knowledge, which would require some inquiry? And in that respect, in our respectful submission, the Quintscare analysis is is both right and well-reasoned. It is recognising that there are two duties in a contract which, in special circumstances, will potentially give rise to a conflict. And those special circumstances will ordinarily not arise. Ordinarily, the reasonable agent in response to the instruction will pay as a matter of course. We are dealing with the exceptional, unusual fraction of 0.0035% of whatever it was in the footnote.
But we're not just dealing with APP fraud, it's the point that's been made before. We're dealing, on your submission, with fraud generally and also mistake.
Well,
I mean, if you rely on the wide formulation in Selingor, which you did rely on,
yeah.
And given that common law works from general principles, it cannot be right to make a decision about extending the common law based on the occurrence of APP fraud.
Well, my lord, I would fundamentally disagree. In my respectful submission, the modern problem, which is APP fraud, is precisely the scenario where the common law has a constitutional obligation to play its part in relation to assisting the consumer and the bank, fashion a remedy which provides for a satisfactory balance between the competing interests. And
fashion a remedy combined to APP fraud?
Well,
confined rather to APP fraud?
Confined. We have no objection to it being confined.
But is that how the common law works?
Well,
I mean, we're not a legislature.
No, in my respectful submission, the common law does work like that. It develops on incremental steps, and let's look at it this way: isn't the quince care duty, in fact, another example of authorised push payment fraud? It isn't what's going on in quince care classic scenario with an agent, an internal agent pushing a payment, but which between the principal and the agent, between the bank and the customer, is authorised.
Well, is it? I mean, that's the whole point about quince care, that the bank is on notice that there is a possibility that the agent is not authorised to carry out that which he or she is doing, and therefore the apparent authority equally is called into question.
There are two questions arising out of that. One recognised by my learned friends in the written case, which is that there isn't any certainty, it seems, on what the test is in relation to when knowledge of actual authority destroys ostensible authority. Secondly, none of the cases actually approach the analysis in that way. So
yes, but the fact that there may be a parallel way of analysing the quince care duty may well demonstrate that whatever one makes of the duty of care, the outcome is a correct outcome.
Well, I think that conclusion, if I may respectfully say so, would lead to the opposite juridical submission made by the bank, which is there is no duty. If you approach the analysis on the basis that notice of a lack of actual authority invalidates the invalidates the reliance on ostensible authority, there is no quince care duty. There is, all that there's left is a breach of mandate claim. That's the logic of their submission. but they don't make that submission. Their submission on their position on this appeal is completely, if I may respectfully say so, inconsistent. You cannot have a quint scare duty if you rationalise it on the basis that your lordships have hypothesised. There is no room left for the quint scare duty on their case. And that juridical analysis is not a fresh one, it's not a new one. It existed at the time of the decisions being made in Selangor and Carac and quint scare. The concept of the potential ability for authority to be destroyed by having notice of a lack of actual authority is actually expressly referred to by Mr. Justice Unger Thomas in Selangor, by reference to a decision of Lord Justice Atkins. If I can, someone can find the reference for me. Unfortunately, my screen is frozen.
Well, shall we?
But if
In that case, might this be a point at which we could adjourn and
it might be, you may
return to this when you've got your screen sorted out?
The clock may have saved me. Thank you.
Very well. Now, there was an authority you wanted us to look at over the adjournment, wasn't there?
The Beale. If I just get the reference for that now for your lordship to see if I can find it. Yes, it's in the bundle of Authority 42, and it's the wrong version.
Oh, I see.
And if you want the reference for it in Bowstead to link to it, it's the Bowstead reference is at
Thank you.
6511 to 6512, and the general rule which is stated in Bowstead then gives you the link to the decision of Beale in South Devon Railway Company for the classical statement of the principle which supports the basis for the article. The short reason why we wanted to draw your attention to it is because, in our respect for submission, it shows that Mr. Justice Stane did not err in his reading of what that textbook said as at that date, contrary to the Watts analysis.
Is this referred to in your case?
It is.
There's a reference to that.
Let's have a look. It will be, I think, in the section near the end, where we...
You do refer to, it's your critique of what,
Yes.
that he misunderstood what Bowstead was saying.
Yes,
as being
it's
confined to a discretionary agent.
Yes, it's just a misreading, in my respectful submission, or wishful thinking on the part of Professor Watts because of an outcome he wants to arrive at, if I can put it that way.
Well, the proposition that he doesn't understand the book of which he's the editor is an interesting one. We'll adjourn.
Thank you.